This is the stuff out of a movie. This is what makes people have nightmares at night. And you instigated it. Devin McGee, cause number 38631.
Your Honor, I'll wait for my client, but he's informed me that he wants to withdraw his plea.
Yeah, I already know that. All right, so are you Devin McGee? And Mr. McGee was previously in court, entered a plea of guilty to...
This hearing takes a dramatic turn. The defendant wants to withdraw his guilty plea. That's not something a judge has to approve automatically. Once a plea has been entered knowingly and voluntarily, changing course is much harder than many defendants realize. Do you think the judge will give him another chance, or is it already too late?
The first-degree felony offense of burglary of a habitation with the intent to commit aggravated assault. And that was, the agreement was for a cap of 30 years in the institutional division of the Texas Department of Corrections. I have received a pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
I have. I've also received, it looks like a letter from Mr. McGee that I have taken notice of, as well as a couple of, looks like some incident reports from the jail. Have you all had an opportunity to review those?
Yes, Your Honor.
I have. Are there any additions or corrections to that pre-sentence report?
Your Honor, the only additions that I would have is that I've received 2 letters from family members. I'd like to have the court have access to that before making a decision. However, I'd like to read from some of the letters as part of my closing.
That was a crucial legal clarification. The defendant believed probation wasn't even possible, but the judge immediately corrected that misinformation. Now, the plea stays in place, and the entire case shifts towards sentencing. One misunderstanding may have completely changed his strategy.
I'd like to hold on to them, but then I would like to present them to the court. They're written by 2 close family members. And then further, the only other correction in the pre-sentence report, I guess we need clarification. While the defendant was previously in court and pled guilty, he's informed me this morning that he wishes to withdraw his plea. I let him know that that was up to the court. That's not up to me.
So, Mr. McGee, when you were here before, you were sworn in by the clerk and asked you some very specific questions about your plea and whether or not you were doing it freely and voluntarily, whether or not you did it because you actually did what they charged you with. Obviously, you know that I sat through the trial of your brother, so I've seen all of the evidence against you that would be presented at trial. The videos, all of the things. And so I guess I'm not inclined.
The defense has now presented every mitigating factor they can. No criminal history, a difficult upbringing, family support, newfound faith, and even a request for probation. But sentencing isn't just about sympathy. It's also about accountability. The question is, will those personal circumstances outweigh what happened that night?
To let you withdraw your plea. I want to know, though, quickly why you think you want to.
I don't want to withdraw my plea because I was informed. Well, I found out that I can't get probation on this, and I thought I could.
And that's not correct, Your Honor. He is eligible for probation.
You are eligible for probation.
So, affirmative finding of a weapon, I couldn't get it.
What?
Affirmative finding of a weapon, I couldn't get it.
If I make that finding, I can give you anything right now from a deferred probation up to 30 years in prison. That's the range of punishment. So you are eligible for probation. That is an option that I have. So that's whoever has told you that, you're misinformed. That is an option. All right. So I am not going to allow you to withdraw your plea. We're going to go forward with sentencing. Mr. Nix, you may proceed.
Thank you, Your Honor. Your Honor, in reviewing the PSI, obviously the court's seen some of the evidence. It's not good evidence, but